good night. Welcome to Legalize this 21st day of September 2025. Welcome to my co-host, Aisha.
Good evening, Mr. Layne. Good evening to everyone.
Mr.
Good evening.
Mr.
Good evening.
Maxron, welcome.
Thank you.
And of course, Ruggles Ferguson Casey, regular on this program.
Yes, thank you. Thank you.
Good night, all. Yes. So before we start, we just recognize the sponsors of the program, Jail Professional Solutions. Jim FM carried the program on FM radio out of Canada, and also Grenadian Technical and Allied Workers Union, Cheetah.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Yes, so the program tonight is quite important because it impacts on the lives of our citizens, or it can potentially impact. And the program was prompted by a development in Brooklyn, New York, with a Caribbean citizen. We are not here tonight to discuss US law. That's not our field. But events in different parts of the world can trigger conversations which are relevant to us. So to set the tone for tonight's program and to set the context and the background against which the program arose, we just watched part of the clip related to that program, to that case in the US. Sorry.
But first,
it's rough, it's tough. I cannot eat, I cannot drink, I cannot sleep.
a homeowner spends decades paying off his mortgage only to suddenly find out his home has been sold in an auction without his knowledge. So how could this happen? It's a 7 on Your Side investigation. And good evening to you. At 6 o'clock, I'm Liz Cho. Bill is off tonight. We are going to begin with that stunning story of a man fighting to keep his home. He worked for 22 years to pay off the mortgage on his home in Brooklyn, only to find out that it was auctioned off. He had been paying his water bill, but it turns out there was an old bill he never knew about. But the city sold the debt to a private investor who then sold his $800,000 home at an auction. And thousands of New Yorkers could be at risk of the very same thing. Investigative reporter Dan Krauth is here now with the exclusive report. Dan.
Liz, the city takes action against people who don't pay their property taxes or water bills. It is leading to people losing their homes. In this case, it's for a bill that was worth less than 1% of the value of his home. In the middle of the night, this is what the Brown family in Brooklyn woke up to. Strangers using power tools to try to get into their home, only to find later those strangers had a legal right to be there.
I don't want anybody to go through what I'm going through. It's more than I can bear.
Fillmore Brown bought his home back in 1996, worked 7 days a week for more than 2 decades to pay it off, only to learn it was sold out from under him.
It's rough, it's tough. I cannot eat, I cannot drink, I cannot sleep. I cannot stay at the house.
That was your American dream.
That was my dream, only dream.
Back in 2019, Brown had just finished paying off the mortgage, but says he didn't know he had an unpaid water bill for $5,000. Did you know that you had an outstanding water bill?
No. If I did know, I would pay just as I paid the balance.
Here's what happens in New York City with larger unpaid water and tax bills. The city sells the unpaid bills to what's called a trust, which is a group of investors. It's then up to those investors to collect the money with interest. If the balance isn't paid, the home can go into foreclosure and be bought at auction. That's what happened to Mr. Brown.
It's stolen from me, and I need it back.
The city says they sent numerous notices warning him of a pending lien, notices Mr. Brown says he did not receive. Court documents then show the investors served someone at his home with papers in November of 2020 during the height of the pandemic that they were foreclosing. Mr. Brown claims he didn't get it.
I would pay it with no problem.
He lives on the top floor of his home and rents out the lower 2 units to other families.
He said he didn't know anything about this, and I believe him.
The attorneys working on his case say he has paid thousands of dollars in taxes.
Yes, so the question was asked by a few people who followed this. Can this happen in Grenada? Can this happen in St. Vincent? Can this happen in the Caribbean? It sounds all dramatic, but can it happen? Has it ever happened? If not, is it likely to ever happen? King's Counsel, we start with you, I guess. You are muted. You are muted.
Oh, sorry. I didn't realize I was muted. Yes. Good evening, all. Good evening, listeners and viewers. Yes, that's very unfortunate indeed. In fact, unfortunate is an understatement to describe the circumstances this gentleman went through. Probably horrific is more like it. Can this happen in Grenada? Hardly likely in small societies as these. I note in the gentleman's case, it was not a mortgagee exercising a power of sale, but it was a debtor, a creditor whom he owed, and in the line of water bills for utilities. I am not too sure what the law specifically provides, but it must provide for such to happen, especially in circumstances where he said he didn't know about it. Is it that he didn't know about it because wherever it was published, he did not see it, or correspondence was not sent to him, so he can address the situation? What will happen here? And water bills, as we know, are relatively low compared to other bills, much cheaper than electricity and other utilities. And therefore, where bills are owing, then correspondence will be sent, calls made. We are distinctly a smaller society compared to the United States. And the aim of the utility is not to sell property or even cut off water, but to ensure that people pay their bills. And I think that is the approach that would normally be taken. I know of instances where bills are owing, and well, they have the draconian resort to cutting off your water. I mean, if your water is cut off, then your first order of business is to try to get it on as soon as possible. So there is that. If you don't pay your electricity bill, they basically cut you off. If you find some other way to get water and to get electricity, there's a dispute over how much is owing, then there is a court that one can that one can go to. But in our neck of the woods, before such a sale can take place, then there would need to be some judgment of the court, and that's for water. Some judgment of the court, I would think, if the draconian route of cutting off the water does not work, and when there is a judgment of the High Court, not even the Magistrates Court, a judgment of the High Court acts as a charge on property. In other words, if somebody takes you to court, gets a money judgment against you, whether that money judgment relates to the property or not, that judgment, once it's a High Court judgment upwards, Court of Appeal or Privy Council, as the case may be, is a charge on property. We have legislation, I believe the Civil Procedure Act authorizes that, and the debt is sufficiently large, and you so your property could be sold theoretically. It could be sold. I suppose later on we'll look at priority at debtors and so, but it theoretically can be sold to recover your money. But
Okay,
even with proceedings, sorry?
With regard to the water rates, the water authority will have to take you to court and get a judgment.
And that judgment attaches to land, and not a magistrate's court judgment. It has to be a High Court and upwards judgment.
Okay, good.
That judgment attaches to land. And therefore, for example, if you have to sell the land, then those bills have to be paid first before you transfer. You can get a deed transferred to the new purchaser. So there will have to be that. And even with enforcement, there are different forms of enforcement. So, for example, there's a process called examination of the judgment debtor to determine what means he or she has. Those means may include monies in the bank, what salary is working for, he or she is working for, what other bills are owed, and the court can make an order, or parties would normally agree to, listen, I will pay off X per month by installments until I pay off the debt. Normally, the sale of property is really a last resort. A last resort, it can be part of enforcement proceedings, but it's usually a very last resort. So
all of this you're saying is specific to water rates.
Well, I'm saying specific to the water rates, in this particular example, because you might have the mortgagee exercising a power seal with respect to a mortgage.
I just want to focus on the water rates for
right.
So
yes.
Basically, we say that as far as we know, in Grenada here, you owe outstanding water rates, they could cut you off, demand their payment, ultimately they could take you to court. They could get a judgment from the High Court if they take it to the High Court. That judgment attaches to the property. And later they could use different means up to maybe the highest, the sale of the property to recover the money.
Sale of property. Mm.
Maxron, how is it in St. Vincent? What's the...
Well, St. Vincent operates pretty much the same in that if there is a debt, for example, water rates, they cut you off. I've never heard about a situation where the water authority took someone to court for outstanding water rates, because the easiest thing to do, I think, if you're in arrears for about 3 months, your bill in month 2 would say subject to disconnection. And then in month 3, it will say that, well, we're going to disconnect you, and they would disconnect you without notice. And also, what happens is that if you have to sell that property, the water rate still has to be paid for the new owner to get back the water. And So, and in, for example, where light bill is concerned, sometimes you have to get the place re-inspected and all of these things. And what the power company likes to say is that if we cut you off, you are not guaranteed connection within the next 48 hours. So I've never heard about a situation in St. Vincent where the water authority or the power company would take someone to court. The easiest thing and the cheapest way to do it is you disconnect the utility, and usually the person would comply. And before you can get reconnected, you have to pay all that debt again.
And
Pay
a
off that
reconnection
debt.
fee.
Yes, and a reconnection fee.
Okay, so it's quite very much the same. So what's about property taxes now, which you pay to the Inland Revenue annually? Because I think in St. Vincent, just in the last few days, there's been some movement on that with regard to inland property taxes payable to the Inland Revenue. You want to speak to that, Maxron?
Yeah, what I noticed, I think on Thursday, the Inland Revenue sent out a bulletin, basically saying that they're going to enforce their tax collection for property tax. Now, this is not something I've ever seen happen before. But how the Inland Revenue usually would enforce outstanding taxes would be when there's a conveyance, you have to pay off the outstanding taxes on the property before the property can be conveyed. So sometimes you might find that taxes owing in the amount of $3,000 and so on, but you have to have that paid before the property can be conveyed to a new buyer. Now, what I've also noticed is that the Inland Revenue actually has the power of sale of the property, but this is not something that I've seen under the Land Tax Act. They actually have the power to sell the property to recover the outstanding taxes. I think we'll get further into that as we continue into our discussion.
Yes.
Mr. Ferguson, what about the Grenada position with regards to outstanding property taxes?
Yes, well, outstanding property taxes, there is a provision where property can be sold to cover those taxes. It is not a route that is certainly is not often used, if used at all, because the power of persuasion, the importance of paying these taxes, that is emphasized. It might be the sole property that you have. I mean, I noted an example, though water, just going back to the example, that the water bill owed was about 1% of what the value of the property was. At the end of the day, what you do is to look for ways to work with the taxpayer and to ensure that those property taxes are paid. What happens though when that property, or if that property is being sold to a new buyer? Now it's a two-stage process. Two-stage in the sense that a vendor sells to a purchaser, the vendor executes a title deed, and the purchaser pays the purchase price. Now, after that is completed, the purchaser's conveyance has to be registered in the Deeds and Land Registry.
Yes.
And
The
as a
conveyance fee, right?
precondition to registration, all property taxes have to be paid. You must pay up your property tax in order to have your deed registered. So you may have paid the vendor. It is now yours. because legal title has been transferred to you. However, it is important, and registration is important, of that title deed. So you need to send it to the to Inland Revenue to get the taxes owing. Inland Revenue would indicate the amount of taxes owing on that property, one. And two, from the transaction itself, there's what you call property transfer tax, which amounts to 5% of the purchase price. And that also has to be paid. So sometimes people, the Inland Revenue is able to retrieve all their monies when there is a sale at times. And of course, the objective is to try not to let interest, because interest is significant in relation to property taxes. So the owner of the property would try to ensure that interest does not run at that high rate and work out some arrangement for payment. So the point I'm making here is that even if you try to escape the responsibility, there are points in time when it will just work against you. Either interest continues to accumulate and you have to just be paying and paying, one, or two, at a point in time when you're ready to sell that property and now you actually have the money, and Inland Revenue knows that you have the money, so they're less disposed to negotiate. Because in order to register, they get their money, and they would hardly do the waiving of interest and all of these things, especially if it's a long-running outstanding debt. So theoretically, yes, the property can be sold, and that is if I would suspect such a draconian measure would be taken if the taxes are really high. But outside of that, there are mechanisms that can be used that makes it in the best interest of the owner of the property to pay these taxes. And interest is one such feature, the high interest rate that relate to property taxes.
But in practice, in the kind of transaction you described, wouldn't it be that whoever is buying the property through the lawyers will ensure that the person who is selling the property clear off the taxes?
Yes, that was the point I was making. So for example, in a classic sale of property, you will have, well, first and foremost, a sale agreement entered into between vendor and purchaser, and the purchaser pays a 10% deposit or some deposit to seal the deal, and then you might have about 90 days for closing that transaction. Now, the closing of the transaction during that 90-day period, the purchaser will be searching title to ensure that the vendor has proper title under our system. The purchaser might be raising monies through a financial institution. But when closing time comes for that 90 days, and those are the things within that 90-day period, you will be ensuring as an attorney for the purchaser, for example, is there property tax owing on this property? And if so, how much? Because as part of the closing of the transaction, the purchaser needs an updated property tax payment for that transaction to go through. So you need property tax, you need utilities, water and electricity, especially if a house is involved, a building is involved in the sale. Those are three critical things that you need: water, electricity, property taxes, always. So if you're selling and your property tax is owing from for the last 5 years, for example, the vendor has an obligation to pay, or an arrangement might be worked out that, listen, it comes from the purchase price. So that is paid because what the purchaser wishes to ensure is that he has bought that property, as they say, free from encumbrances. So, because what happens if that is not paid off, it's the new purchaser then that would have the responsibility of having those paid off and the reconnection and everything done. So, of course, no new diligent purchaser would want that to happen. So, it is critical before closing that the property, those property taxes are paid.
So, Casey, for example, if something like that slips on the radar, let's say during closing, the closing procedure, what rights does the purchaser have in terms of an action before the court? So they're
The
outstanding.
purchaser,
Mhm.
yes. Yes, well, the purchaser can go after the vendor. The vendor, as far as those taxes, is really inconvenient to do it at that stage, though. But ultimately, as far as the um, inland revenue is concerned, you still have a responsibility, whoever is the new, in order to get their taxes sorted out. Because the taxes run with the property, not with the individual. And therefore, the property is there, the property taxes are attached to the particular property, and the new purchaser then becomes responsible for squaring it up. The vendor has already gotten his money. He has already disposed of the property, and therefore it's just an additional headache. It will be sorted out. But you have an obligation and an opportunity to do it at the stage when it's closing. If you don't do it, you can go after the purchaser after it is his debt, but that is as between you and him. But as between the main man, who would be inland revenue, then it's the inland revenue and the new purchaser. An example, a parallel example that probably happens too frequently, that freaks a lot of people out, those people who go through the experience, is that you may buy a second-hand vehicle, for example. You negotiate, you buy a second-hand vehicle, you pay the owner of the vehicle. The vehicle is transferred to your name. A month after you're driving in town, and a bailiff stop you. Why? Because there's a bill of sale associated with that vehicle. A bill of sale with a financial institution. The bill of sale attaches to the vehicle, not to the individual who owns the vehicle. I just use that as a parallel. The person goes, the vendor goes his merry way. The previous owner of the vehicle goes his merry way, but the vehicle is there to still seize. And in the case of the new purchaser, he has the responsibility, he or she, to have those taxes cleared so that his business can ensure that he has no problems moving forward.
So let me ask, what's about a lot of these properties we see around Grenada, including downtown St. George's, which have been there abandoned for sometimes generations? And if no taxes have been paid on them, what happens? No property taxes.
Or what could happen?
Or what could happen, yes.
Mhm.
Yes, well, those taxes accumulate, interest accumulates, and at the end of the day, no, one can move on the property. That's one of the one of the options. One of the issues with a lot of these seemingly abandoned properties is because the property itself is in dispute as far as ownership is concerned. Who really owns the property? It might have been owned by somebody before who didn't have a title deed, and therefore there are issues associated with it. Or there might be a title deed, but everybody waited a long time before trying to sort out the title, and you have now 50 people have interest in it, and it just makes it difficult to do something about it. But one of the issues, of course, would be routes of selling. There'll be power to sell that property, those properties, and then, of course, the alternatives of acquisition and so. So there are different ways to deal with it.
Given that they may have dispute that nobody knows who really owns it and who can sell it, and you have 20, 30 years taxes accumulated and being owed on the property, does inland revenue in those circumstances theoretically have the authority to sell the property? Or is it that they have to identify an owner, serve them a notice, whatever it is, in order to do so?
Well, the theoretically, yes, because for property taxes to accumulate on the property, there's always some name associated with the property. Now, the name of that person associated with the property may be a deceased person and may have died several years ago. And the thing is, but that's one of the issues. There's a power of sale, and when you exercise sale of any property, there has to be a movement of title from one owner to the next owner. I suppose there are certain legal issues that may arise in those circumstances because the law provides for the conveyance of the title, in fact, by public auction. And the vendor in those circumstances getting good title. One of the things that we have to recognize is that unlike places as the US, we again live in very small societies.
Yeah.
And there's always somebody laying claim. They might let the whole thing go for over years. But somebody might eventually lay claim. And one of the things that people do frequently, even when properties are in dispute, is to try to get the property taxes paid in the meantime, with the hope that when the estate is sorted out as the title and ownership, you will become, for the purpose of those taxes, a creditor of the estate because you paid taxes. So the estate owes you. It's not your personal responsibility. You have been doing it on the part of the estate. But theoretically, strictly theoretically speaking, it could be done based on the law.
Well,
it's not something I would necessarily encourage, but it could be done because there are provisions in the Property Tax Act that relates to the sale of properties.
I wanted to pull Maxron in here. And I wanted to hear about the St. Vincent position because I assume I visited St. Vincent, but I cannot recall seeing a lot of derelict buildings around. Maxron, is what happens when something like that arises?
Well, the thing in St. Vincent, it's pretty much similar to what happens in Grenada, in that where you have abandoned properties, sometimes you find that there are taxes owing on it. And as King's Counsel said, there are provisions in St. Vincent, I think it's called the Land Tax Act. And there are provisions for the sale of the property if you cannot sell the goods of the defaulter. So that exists in St. Vincent. The provision exists in St. Vincent. And what you find is that in reality, as King's Counsel said too, there are issues with regard to the ownership of the property and who actually owns it, because sometimes you find that it is vested in an estate because someone died years ago. And sometimes you find that the reality is that person who died, all of their children are overseas. And the only time they're really concerned about taxes is when somebody approach them and say, oh, we'd like to purchase this property you have in Kingstown that is really dilapidated and abandoned. And then you go and you do the relevant searches and you find that since the person died in 1984, that the taxes are owing since then. And what persons try to do is they try to set it off from the purchase price, because most of the time what you find is that the persons overseas, they're really not interested in a property in St. Vincent for some reason I don't understand. And they would say, well, I'm not really interested in coming back to St. Vincent. So the property is there. So you approach the person and then there's an outstanding tax on the property. And really and truly, that has to be settled before the sale, before the conveyance can be done. So the approach in Grenada is pretty much the same as St. Vincent. As King's Counsel said, it is there in theory, but in reality, it's not something that the Inland Revenue, I know, exercises.
Interesting.
Sorry.
Go ahead, Mr.
Yeah. I suppose it could lead to all kind of legal issues, legal issues too, because that person who is paying off the taxes, for example, say, well, listen, you negotiate with Inland Revenue to use the purchase price or proceeds from the purchase price to pay off the taxes. Now, a challenge that may arise there is that the person who is paying off these taxes may not be the person who has authority to sell that property and pass legal title to the new owner. So, for example, the purchase of land is really at the end of the day the purchase of the title of the land from the previous owner. So you have property that is sitting there abandoned. First and foremost, it might have been left by somebody who died intestate without a will, let's say, and who had about 5 children sometime in the 1980s. And these 5 children among them had 5 more. 25 people enter the picture, and these 5 more have 2 each. You know, 50 people enter in the picture. And there's, the process of partition of the property and these things. So sometimes it's just difficult. Even when someone pays taxes and that person himself or herself is not the one who is vested with legal title in the property, because you have some people who some in Canada, some living in the States, some living in England, and it becomes a very expensive process to sort out the title to the property. So I'm just raising that as some of the very practical problems that we face in this part of the world. And as Maxron is on, I again make the point that Grenada and St. Vincent are the only 2 countries in the Caribbean and possibly the world operating under the unregistered system of conveyancing,
Exclusively.
which is that long process of searching for title and going back to find a root of title. And in our case, it was 160 years, doing a search 60 years back. Now it's 30 years. The law was amended, it's now 30 years. But you have to make sure that the chain of title from the root through the chain to the new vendor, that all of that is intact before you can transfer the property. So there are these inherent issues, especially when it comes to conveying properties in Grenada and St. Vincent, that would add to the already existing challenges.
But let me ask this question as a prelude to a follow-up question. If inland revenue, for example, Grenada St. Vincent, exercises its power to sell the property because of a massive amount of accumulated taxes, what is the obligation in carrying out the sale? Is it just to sell the property for the taxes owed, or they have to sell it for the market value?
No, well, yes. I think they will definitely, if they're exercising a power of sale. In fact, any creditor where you exercising a power of sale, you can't just take, for example, a $500,000 property and say you're selling it for $50,000 because there's $50,000 taxes owing. You have to exercise due diligence because to get a reasonable price for the property based on the market value. In our Property Tax Act, we have section 51 of the Property Tax Act, which says, where any property tax is due and payable, the comptroller may sell any property in respect of which such property tax is due and payable for the recovery of such property tax. That's 51 subsection 1. 51 subsection 2 says the power of sale conferred by this section shall not be exercised until such property tax shall have been in arrears and unpaid for more than 2 years after the same became due. And then you have sale by public auction. It does not, right, conveyance to purchaser, that's 56. The conveyance to purchaser and application of proceeds of sale. 56.1 says, upon the execution of the deed of conveyance or the assignment to the purchaser by the comptroller in accordance with section 55, the property described in such deed shall be for the purposes of the Conveyancing and Law of Property Act become vested in the purchaser, freed and discharged from all estates, charges, and encumbrances.
Right. So my point is
And
that,
then two.
sorry, no, go on. Because
Yes.
having read that, I was coming to my point.
Okay.
Sorry, make the follow-up.
Okay, the application of the proceeds of sale.
Right.
The purchase money shall in each case be applied in the first place in or towards payment of any cost incidental to the sale of the properties, which shall include any costs or charges incurred in relation to any previous endeavors to sell the properties, and in the next place in or towards payment of any property tax at the date of such conveyance or assignment, and the surplus, if any, shall, subject to section 58, be paid to the person who shall be entitled thereto. And then
Right.
it says in 57 how you dispose of the surplus of the proceeds of sale. The surplus here being after you pay the expenses involved in selling the property and after you pay the property taxes owed. Because that property may also be subject to a mortgage, or it may be subject to judgments of the High Court.
Okay, got
And
it.
therefore, those are paid off in
Right.
order of priority by which they fall. The mortgage normally falls very high on the priority list.
Okay. Maxron, is this more or less the same as Vincent?
Well, in St. Vincent, they have a number of provisions in the Land Tax Act. Section 36 allows for a fine. So if the accountant general does not receive outstanding taxes, then it provides for a fine. It provides for also imprisonment for failure to pay. And it also provides for sale of goods. And if all fails, then it provides for sale of the realty by the defaulter in Section 46. And of course, that will be market value because Section 46 actually speaks about what happens to the balance. So if, for example, the market value is $500,000 and the default is $200,000, it speaks about the balance being held by the accountant general and persons can make claim to it if you are served and if they don't hear anything from you. But if you are served and you deny the person's entitlement to it, it provides for going to the court and the accountant general paying the remaining balance into the court. So in St. Vincent, it has a number of provisions before we get to the absolute sale of the property.
Right. So the question I wanted to ask, I've been said all this year, and I'm only asking the question, whether, given that the controller can pass a good title through the sale, and of course, you have to see the market price, and there's a way of accounting for the surplus. When you have these issues with these abandoned properties, for example, with all of these 50, 60, 100 people having interest and it becoming almost impossible, given our system of conveyancing to sell, would it be more efficient for the controller to sell the property? Will it be a more efficient way of handling things? Because the controller can pass a good title in one transaction. The controller holds the money, and then all who have claims, they make the claims against the monies in the hands of the controller. Wouldn't that make for a more efficient system?
In terms of passing title, yes.
Yes.
Because if you have title that was never touched, and again, it emphasizes the importance. All of this emphasizes the importance of dealing with properties as soon as possible, or certainly within a reasonable time after someone passes on. And whoever is responsible for inheriting that property, whether by will or based on the laws of intestacy, those steps should be taken. And that's where education and public information is important, because especially when it relates to buildings, somebody dies, other people continue staying in the building. Everybody knows that is ex who dead house. There is no real problem or issue, of course, until you have now something arises or some dispute arises among the family members themselves. And you then see the importance of, for example, if there's a will and an executor is appointed under the will, to apply for probate of the will. If there's no will and the laws of intestacy apply, somebody who is beneficially entitled under the law. For example, if there's a spouse, or if no spouse, any one of the children can apply for letters of administration. So you sort out these things. Because once you don't do that, the procedure that I have to go through, I'm sure it will be much easier for the comptroller to convey title and then pay the monies in the court, whatever surplus exists, and let the people who aim to be entitled to it establish the entitlement, and then it's paid out accordingly. But
Of course,
it's a series of
that only,
different, a coincidence of different challenges that arise when it comes to properties, and especially old abandoned properties that again reflect on our own land system and the need to change essentially from a unregistered system of conveyancing to a registered system, because it makes life so much easier. It's not perfect, but it's much easier than what we have to go through in order to sell land and pass title in Grenada and St. Vincent.
Well,
okay,
Casey,
go ahead, Aisha.
I just wanted you to explain the registered system a little bit more for the sake of the viewers, because I know on many shows we've mentioned it, but I don't think we've
Yes.
ever delved in too deeply about what it is, so that they could understand why now, if we have this system, land transactions and the whole issues of land would be easier in Grenada, and this would apply across the board too, right? It's in Vincent.
Yes, exactly the same question I was going to ask and the same statement, because some people will say, well, they don't understand the difference between this registered and unregistered, because they always register their deeds in the deeds and land registry. So why are we talking about us not having a registered system? I mean, it's not the focus of the program, but if you can just say a few words to because
Yes,
I
let
think
me
we
see
have
if I
several
can say it in a mouthful.
Yeah.
Is simple mouthful. So, for example, when you're dealing with land, buying and selling land, then the transaction ought to be registered. And it's registered in your land registry. They call it your deeds and land registry, as the case may be. And why? Because if you want to know who owns a piece of land, who has legal title to that land, you are supposed to be able to do a search in the deeds and land registry, because the person's title is supposed to be registered. So, a land transaction, to put simply, let's use the example of purchaser and seller, is that a purchaser is buying the legal title to the land. The land is immovable. 500 years from now, it will still be there. Unlike a vehicle, you could sell it in St. George's, you're going up to St. Patrick's or Caracou tomorrow. The land remains there, but what is transferred is the legal title. So the big question a purchaser has to ask always when purchasing land is, does the vendor have good and valid title? Because that is what he's buying. Good and valid title to the land. No. Under the registered system of conveyancing, it's a system of conveyancing used throughout the region, because we had the unregistered system. I'll come to that. But more and more, like Antigua had it for years, I think probably the 80s or late 70s, Dominica similarly, they had a registered system. And what's a registered system? Is that there's a register, what you call the certificate of title, right, reflects to that land. The certificate of title has the relevant information regarding the ownership of the land. And once the certificate of title says the owner is X, the owner is X. You don't have to go and search for 60, 70 years, 30 years to find if that owner has valid title. The certificate of title represents what is called indefeasible title to that property, right? It's reflected. So it's a particular system. So that system says Aisha Mclean is the current owner of the land, recorded on the certificate of title. She is the owner of the land. You still might have to check the land to see if there is any building, if there is any squatter on the land, these things. But who the certificate of title says owns the land, owns the land. However, under the registered system, unregistered system, and sometimes it can sound contradictory because your deed is always is registered in the deeds and land registry.
Or we can use it by recorded.
Recorded, yes,
Maybe
it's
we can
recorded in
record
the
it by
deeds and land
easy.
registry.
Mhm.
No, when and the evidence of ownership of property, the evidence of it is your title deed. So you buying from X, does X have a title deed? And that title deed will say who X purchased that property from. However, that does not necessarily mean that X has a good title deed. As I say, that title deed may not be worth the paper it is written on. And I have all the nice green ribbons and the deed paper looking good, but it may not reflect good title. Under the unregistered system, you have to go to find what is called the root of title. The root of title, a good root. And a good root includes where it was conveyed to whichever purchaser, or a good root may be a will. Now, before the actual law was changed, in about, is it 2016? But before that, you had to go and search for 60 years to make sure that that land has a good root of title 60 years before now. And then when you find the root, suppose you find a root that X conveyed it to Y there, right? So you find where it was conveyed is a good root, then you then have to, in your what you call forward search, ensure that the chain of title remains intact. So under that system, you have what is called a root of title and a chain of title. These concepts don't exist in the under the registered system. What exists, the most important document, is the certificate of title. So for example, let's say your root is found, and by the way, the search for a root now, you go back 30 years. Before it was 60 years, but it's now 30 years. And in that period now, you're searching, let's say, A conveyed to B, right? That is your root. You find A conveyed to B. Good. B conveyed to C. Okay. Then C died. C left a will, and I'm just using an arbitrary example. C left a will. C divides that property to 5 children. And now, when you're checking now, the deed that followed after C's death, you see 4 children signed that deed. It was not signed by the 5th. There's a defect there already. Right? Right? And C had 5 children. Numbers 1 sign, number 2 sign, number 3 sign, number 4 sign, but number 5 didn't sign. And number 5, who had an interest in that property, might have 5 children. You have to go and fix that defect, which falls within the relevant period. You have to go and fix it. To go and fix it now, number 5 might be dead already. And then has 5 children and died intestate, no letters of administration. What I'm saying, it can be a nightmare. Because all of these things, these technical defects have to be fixed in order to ensure that good title passed at every stage of the process. So in other words, that's why those who are familiar with the books in the deeds and land registries see all these fat books, libels, that people have to physically go through. They're in bad condition, pages missing because they wear and tear from searches every day. So you have to go through all that. So what I'm saying is that, and even now, as some search clerks do, is say, well, listen, we can't guarantee titling because pages 5 to 20 missing in this book, and we ain't too sure if the mortgage somewhere in between pages 5 to 20. So I'm just saying that we still depend on that very old system and a registered system. And I say, just remember, in a sense, the state guarantees title, and that title is reflected in your certificate of title. You don't have to go behind that.
So let me see if I could just ask us a way to summarize. Are you saying that under the registered system, all the relevant transactions related to the particular piece of property is contained in just one single document?
Yes.
And that one single document will say...
There's a register.
Right. And that one single document will say at the point in time, who is the owner of the property? And that the state guarantees that. So it is not necessary to look behind the register.
Right.
Okay, but you're saying now with the system we use in Grenada, where all we do is to record deeds in the deeds and land registry, and by the way, in St. Vincent also, in order to, first of all, the title is not guaranteed, and in order to find out if there is a valid title, you have to go back at least 30 years to find what is referred to as a good root of title. And then you have to trace all the transactions from that route up to the present owner and make a determination, and that you may find many defects in the title.
Yes.
Which will take time and resources and so to correct.
Precisely, and especially if you find defects, and depending on how far back that defect is, and who is required to correct the defect, if that person is alive or dead.
Yeah.
Sometimes you even have to make an application to the court.
Yeah.
To deal with it. Yes.
Okay. So just hold on now. I just want to recognize the sponsors of the program, Jail Professional Solutions Inc. Gem FM carried this program out on FM out of Canada, and also Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Right. So in terms of summarizing this first part, I think we can just say that With regard to property taxes, both in Grenada and St. Vincent, ultimately the Inland Revenue has the power to sell property in order to recover unpaid taxes. Ultimately, but it is not a practice that is employed. So what's about now private mortgages with financial institutions, the banks, the credit unions, and so on? Do they have a power to sell property to recover debts in cases where lenders default? Maxron, we can start with you. In St. Vincent, how it goes there?
Yes, in St. Vincent.
You have a particular statute governing that?
Well, the thing is, we have basically the common law still governing this, and the mortgage operates basically as a contract. Now, in St. Vincent,
and by the common law,
the practice,
it's not written in a statute.
Right. So what happens is that what is supposed to happen in theory is that if you default on your payment by about 3 months for some financial institutions, they actually have the right to foreclose. But what I've noticed happening in St. Vincent is that sometimes the financial institutions would wait 1 year, 2 years, 3 years, 4 years, 5 years. And what would happen is that by that time, the interest is so high that when they are ready to foreclose, I don't know if it's a strategy on their part to try and recover more money than what was initially outstanding. But when you wait 4 or 5 years to foreclose on the property, then it's like starting the mortgage all over again. And then you issue the notice to the persons in the property and say, well, we are going to sell. And or someone bought the property and you have to leave. And sometimes you have to take the persons to court for vacant possession. But sometimes it works. What I notice in St. Vincent is that these foreclosed properties, they're usually abandoned because someone migrated and or someone died and there was no life insurance and the property remains indebted.
And just for clarity, when you say foreclose, you're speaking about selling the property?
Yes, selling the property, the bank selling the property. Yeah.
They need to get a court order, or could they sell it without going to court?
Usually they sell it without going to court. The only time they go to court in St. Vincent is when persons are still occupying the property and they steadfastly refuse to leave, and you have to go to the court to get vacant possession. In St. Vincent, that's usually when the court gets involved.
Okay.
And Casey, is the Grenada position similar?
Yes. Well, yes. So you have the mortgagor. Two concepts here: the mortgagor, who is the borrower, and the mortgagee, who is the lender. So, and you have the mortgage document, what you call the mortgage, where legal title passes from the mortgagor or the borrower to the mortgagee. And that is an important aspect of this power of sale. Because remember, any sale involves passing legal title. So if you don't have the legal title, you can't pass it. Right? So, and there are different kinds of mortgages. You have the legal mortgage, where the borrower has passed legal title to the property to you, or you may have an equitable mortgage, which requires not the passing of legal title from borrower or mortgagor to mortgagee, but you might just have the holding of that original title deed. That might be associated with much smaller loans. So in the mortgage document, so for example, just to give an example, so we'll see it from a real life situation. B buys property from A. So A conveys the legal title to B. B pays A the purchase price. Now, in order to purchase that property, B didn't have all the money. So B went to financial institution C to raise the rest of the money. So what the financial institution does is to enter into with B a mortgage. And in the mortgage now, B now conveys legal title to C. So the financial institution has the legal title. And therefore, the question was asked if they can exercise, and the mortgage itself would have provisions for the exercise of the power of sale by the financial institution. And why it can exercise power of sale? Again, because it has legal title. If it does not have legal title, then it can't pass legal title to any new purchaser. So, and it's the Conveyancing and Law Property Act. They also have provisions regarding the power of sale. So, the property is in uncontrollable arrears, as the case may be, whatever arrangement is worked out, and most times these financial institutions, again, is a small society, and the focus is to ensure that the financial institution does not lose, because financial institutions, probably most of their money come from interest on mortgages, or certainly a substantial part of their monies, interest or profit, come from interest on mortgages, payable over a long period of time. So the mortgage document has the actual power of sale provisions. So when things go south, as the saying goes, and the bank moves in to exercise its power of sale. And why it has a power of sale is again to ensure not just the power of sale, but the mortgage, to ensure that if the mortgagor can no longer pay the mortgage, then the bank or financial institution is not left empty-handed. So, so you have that power of sale and power of sale in the mortgage, and the law, the Conveyancing and Law Property Act, actually regulates that sale. In other words, it can't be just arbitrary. You sell the property. There are procedures. In fact, there have been lots of litigation regarding exercise of power of sale in the OECS and in Grenada too. You have that, because it has to be properly advertised. Again, the question was asked earlier about the property tax, if you could just sell it for what is owed. And the answer is no, you can't just sell it for what is owed. And you will hear that financial institutions are not into the business of selling properties. So the preference would be not to sell a property, as a matter of fact, but to work with the borrower and try to work out some arrangements where you have a win-win situation. Because all these people will be you want them to be future customers of the banks too. So you work with them, and it's not usually the first, you say, oh, you're arrest 3 months, let's sell the property. There are lots of discussions taking place between the parties. I just want to say too that the conveyance from vendor to purchaser is a transfer of legal title. The mortgage is also a transfer of legal title from new owner, purchaser to bank. However, the difference with that is that there is what you call the equity of redemption, where the bank can't just sell the property like that because they have the legal title. There are restrictions as to what the bank does regarding the disposal of that property, and it's a requirement of the law that when the loan is repaid, you are bound to reconvey that property to the original owner. So you can't say, well, I had the title deed, we have it there, we could do what we want. The owner always owns what is called the equity of redemption in the property. So that's why at the end of it, you have a reconveyance of legal title from the bank to the borrower. So the borrower now has free and clear title again.
That is when the loan is repaid.
Yes.
But of course, you can sell the property if there's a issue of collecting their monies, the person is in default, they can't pay. You could actually sell the property to recover the monies.
Right. Or sometimes the borrower is the one who does all the negotiation, sells the property, and then pays the bank off. So the bank then is a sort of simultaneous operation because many mortgage properties are sold. So what happens is either if it's a bigger property, and you're just selling piece, so you have 1 acre mortgage, for example, but you're only selling quarter acre, the bank will have to join in that sale to release the quarter acre from the mortgage. If it is the whole, then purchaser, it's done, say, almost simultaneously. There's a sequence of registration here. So when you get the purchase price, the bank is paid off. The bank does a reconveyance to the owner, the vendor, and the vendor does a conveyance to the purchaser. When it's not a portion of the property you're selling, then the bank does not normally join in that conveyance to the new purchaser. It will reconvey the property to the owner, who would then sell it free and clear to whoever new buyer waiting in the wings to purchase the property.
But this new buyer will have to pay off the bank as part of that process.
Yes, so in other words, you're paying off the bank with the purchase price.
Yeah,
with the purchase price you receive. So all of that will be done before you get the remainder of it in your hands, of course. So the lawyers would have the signed documents. The purchaser passes the money, and the mortgage payment is deducted. And the deal closes there. That's with an ordinary sale. But these things are last resorts, especially, as I say, where we live in small societies and people face all kinds of challenges from time to time, and it might be their only asset. It might be the place they live. And one of the things that people do is to then just forget the bank and do their own do because they feel, well, hey, this thing reach a point of no return. But it's always good to engage, engage. And, financial institutions generally will try to work with you as best as possible because they want a solution too, just like you. Because when you have to go and sell that property, you have to go through all notices, give notice, publish on the newspaper, and you have to make sure that all of these things comply with the law too. Because you have had situations in the past where properties have been sold, and the owner comes back and sues for selling
Right.
at
So
an
I was
undervalue.
So I was going to ask a question. We regularly see in the newspapers, in fact, these advertisements for auctioning off of properties. That will generally be a reflection of a default on a mortgage, and the mortgagee looking to the lender looking to exercise the power to sell the property.
Right.
Okay.
Yes.
Mhm.
Generally. I think the same because St. Vincent ourselves, I believe, and when you look, so people look in newspapers for the ads. They want properties, they look at the ads and see which properties are being
Being
sold.
sold out by the banks. That is so in St.
Yes.
Vincent Maxron is regular.
Sorry, I got lost in
Yes.
the middle of the question.
Right. We are addressing the issue of the regular notices in the newspapers. Sometimes a lot where
Yeah.
properties have been advertised for sale, and King Songs was confirming these are really instances where banks, lenders are seeking to enforce the power to sell the property for property owned by by borrowers who have defaulted. So I was going to ask, how regularly do you see that in St. Vincent?
Of course. I think I've been seeing them weekly in the newspaper, to be very honest. Um, they actually would invite you to make an offer for the purchase, and it's up to you to write a letter. They would direct you to a particular law firm, not to the bank, but to a particular law firm to basically put in your offer. And sometimes they actually generate a list. If it's a lot, you would see a list and inviting persons to make an offer on them. And sometimes I think what the bank does is that you never know if your price is good enough, because what the bank is usually concerned with is if they're going to get back the amount that is owing. That is what I've noticed with the attitude of the banks in St. Vincent. So for example, you'll see a property and you may get away with offering 300,000 for it, even if it might be worth a little bit more. That is what I've noticed. Um, that's what I've noticed happening in St. Vincent. It's really up to the bank to accept um, or reject the offer that you put down. Some persons, they look out and they just make random offers every week and see if one of them would be accepted by the bank. But I do see them weekly in the Vincentian newspaper.
So you don't have much auctions, public auctions. Because
No,
I
I've
think in
not.
Virginia here, that's more like what you have. You have sometimes what they call by private treaty, which is what you described that you're setting up in.
Yes.
But I think in the newspapers in Grenada here, what you most see is there will be an auction at so date, and you agree with me on that, Casey?
Yes. Yes. So you have private treaties, you have auctions too. And again, I must say, the bank, you would usually see when these properties are advertised for sale, you usually see a reserve price. Now,
Yes.
that reserve price again is the price based on the valuation and everything on the property. you can't say, well, they owe me half of that. So the property value $500,000. The borrower owes $250,000. So, and I get an offer for $300,000. So I go with that because the bank has to exercise due diligence and ensure that, for example, it's advertised. And when it's advertised, when people come out this week, there is no there's no buyer. You can bring it down by 10% and so over a period of time. But you cannot, even though you have that power of sale, but you have to be very diligent to ensure that that property is not undersold and gauge against what is owed by the borrower as opposed to what the value of the property is. Because you are selling it not just for yourself. The surplus then has to go to the owner of the property
So,
after it's sold.
so Casey, it's fair to say that the bank now assumes a fiduciary responsibility to the owner, well, the payment size owner.
Well, they certainly they have a legal responsibility to ensure that that they just don't arbitrarily just sell a property. For example, you have this case that it was Batiste and one of the financial institutions many years ago. Batiste owned a house in Lansapine. He had a business for which he was going into a manufacturing business. He had big dreams and borrowed monies from the bank and used his house. It was a house in Lansapine, mortgaged that house to the bank. The business fell into problems, and what the bank did know was to sell the house at Lansapine to pay off the mortgage, or rather part of the mortgage, because it was not sufficient. So they paid, they sold the house, reduced the loan significantly, but then after they claimed $500,000 owing. And basically, to submit the essence of it, Batiste denied that he owed them any monies, and essentially it was argued that, listen, you sold that house at an undervalue, and it was valued more than than what you say I'm owing you. No. The plus $500,000, and basically the court ruled in his favor that the bank did not take steps. In fact, after that case, a lot of the financial institutions then changed their whole approach to how you advertise properties, for example. You can't just advertise a property, say property for sale, $500,000. If you notice with these advertisements, we'll go in detail. The facilities available, the land, the kind of house on the land, if there's a house on the land, how close it is to the road or some key place. So it is pitched to attract people who would want that kind of property and can immediately see the type of property it is. And it was found that the bank was wanting in that particular advertisement when they advertised this property. So essentially, the court dismissed the application for the added for the added monies, they dismissed the application and he didn't have to pay the $500,000. I mean, I just use that as an example. That case was used, in fact, not just in Grenada, but outside too, as the kind of precedent as to how financial institutions should approach the sale of mortgage properties.
We have some comments from our viewers. Sonia says, and with reference to our earlier discussion, and your down payment may also be increased if you habitually fail to pay. Bob comments, this is a major, major problem. I think he was speaking about the relic buildings. But let me go ahead. This is a major, major problem in Grenada. That is land and title. I can only ask questions as this is beyond me. Something has to be done to lessen the problems. He also comments, Bob further comments, I do remember the old days. The city of NY sold abandoned buildings for $1 with very stringent conditions before the court would give you title after 7 or more years. Bob further states, but you had to completely upgrade the building to a rentable and taxable condition in the prescribed time. And he says that he knows the Baptiste case very, very well from the local media. So Bob has been following us very closely this evening.
Yes. So let me ask, I love you. And of course, this is not legal advice. We're just having this for public education purposes. If I'm a borrower and I face a situation where a financial institution is looking to sell my property, what kind of steps are open to me to seek to prevent that, if any?
Well, what I've noticed in St. Vincent is sometimes you have children of the mortgagor stepping up and saying, okay, well, I am now 21 and I'm working and I would like to come in and take over the mortgage. And what I notice happening is that the financial institutions, again, because they're really interested in getting back the monies owed to them, they usually negotiate with that child. So I know in one instance, the financial institution agreed to a waiver of all the interest that was outstanding since the loan was not performing. I think maybe 3-4 years or so. And the child came in and took over the mortgage and basically saved the house from foreclosure. What is also open to the mortgagor is they can actually, if they realize that they can't go with the mortgage, they can actually sell the property and a possible downsize. And again, they can have the necessary conversations with their financial institution, whether a waiver of interest and so forth, to try to get out of that financial strain. And I think that is what works a lot in St. Vincent from what I've seen, is that you had a $500,000 mortgage and a huge house. And of course, the house would have appreciated in value. So now it's no longer 500,000, but maybe 800,000 or 900,000. And they sell it and get the difference that they get is really, really good, that they can actually get a good foundation in starting a new house or downsize, so to speak. So those are the two things I've been seeing in St. Vincent.
Mm-hmm.
Yeah. Well, yes, engagement with those who have the power of sale is critical. With your bank, again, to work out what is the best formula. You may wish to, for example, bring in as Maxron said, you may have, family members, children who can come to assist. And there are various ways. Remember, we operate in a very competitive environment, and customer service is critical. In other words, it's not just one financial institution that you that operates in the market that has a monopoly. You have several banks, and now you have credit unions expanding in a significant way and offering big mortgages too, right? So it's a competitive environment, and the bank relies on customers. The bank relies for a significant chunk of its profits on mortgages. So you don't want people to just get up and go from X institution because Y institution happily is waiting to embrace you and work out something. So I'm saying it's critical not to turn your back on it and feel, well, everything is lost, so let me just ignore everybody. Let the bank do what you want to do, and I'll be there. Whatever happens. I think the engagement is critical, and to seek independent advice from experts in the area as to what are the possibilities. Because sometimes even all rescheduling of loans, right? Rescheduling loans is something that's available. Borrowing, rescheduling, all of these are critical. And sometimes another financial institution, given where it is at times willing to pay it off and take it over and enter into some new arrangement with you. So there are alternatives, there are options. And the thing is that people should explore, even with lawyers. With lawyers, there are independent financial advisors, other institutions you can speak with, but first and foremost your own institution, because they can do a lot, especially in the department of waiving interest and not losing. Right? Could waive significant interest and still not lose.
Would you say it is the absence of information out there? When I should ask first, have you come across situations, and if so, how regularly, where borrowers just throw up their hands, surrender? What happened?
Yeah. Yeah. So now I'm surprised actually. And it's just frustration. As I say, knowledge is power. And I've interfaced with borrowers who just feel to cope with the stress, the easiest thing to do is to switch off. Right? Don't worry, it's like what happened because they feel overwhelmed. But there are many ways, and then you avoid your creditor, in this case the bank. As I always say, there may be some unreasonable creditors, but most times when you owe people, everybody owes somebody for something. What the biggest concern is when you turn your back and the people have to fight up to fine you and get money. When you engage, and you continue to pay, even if you can't pay the whole thing, but you continue to pay, then people tend to work with you because you're showing good faith. I'm not saying it will happen all the time, but at least some kind of engagement is important at the and with the financial institution while you explore other options, because experts themselves may be able to put forward proposals that can, that can get you out of it. Others can take over the loan. There are all kinds of ways. You might give the children or whoever interest in the property to save the property within the family. These kinds of things. They all work. But just a general comment that, a general comment here, observations that, and I've had the experience with it. You have the mortgage document is usually prepared by the bank's lawyer. So even with a transaction where A sells to B, and that's B the purchaser has a lawyer. That lawyer takes care of the title deed, prepares the title deed from purchaser A to B. Now, B is also taking a mortgage. And the bank's lawyer, B has engaged C, the mortgagee, has an independent lawyer who is preparing the mortgage. And most times, people, they get a call and they say, well, come and sign the mortgage. Come and sign the mortgage. And people are so anxious to get the money that when it reaches, just wait to sign. And sometimes people don't really understand these documents. Understand what they are signing on, save and accept that you borrow money and you must pay it back. But all of these different conditions, and sometimes there are penalties contained there for even paying back the loan early. And people don't know about it. They discover that when they try to pay back the loan.
Having said that,
Sorry?
Having said that, if the person has a lawyer working for them, shouldn't the mortgagee or the mortgagee's attorney walk through the lawyer rather than work directly with
Exactly.
them?
Precisely. Because nobody understands the mortgage document. And that's, again, all the kinds of changes that ought to take place in the system. Where I come in and ask somebody to sign something, and even when I tell them read it, they won't understand that. When I read about the second paragraph in the first page, that is, your head started out here already. You didn't even want to go on because it's written in legalese. But they're signed. I remember specifically once, making a request to see the mortgage that the purchaser had to sign. And when reading it, saw certain provisions there, and saw a provision that, even though the purchaser tried to pay back the loan early, there'll be a penalty, right, on it. So you come here and say, well, no, no, the financial institution has power. And that's the power that is leveraged at that time, whether it's like take it or leave it. Or some of these documents can't change. Or no document is fixed in stone. And it can be changed, right? Because you went and sign it. You went and sign that document. You must understand the fundamentals that are in there. And I find too many times people they wouldn't understand the fundamentals because the way it is done is that they just go, and even though you explain to them in simple terms, this is a document, several pages. You give them to read. They say they would hardly understand. And that is a practice that ought properly to be addressed, where the purchaser's lawyer has the opportunity to review the mortgage too. Review the mortgage and those obligations are properly explained. You know, because usually you're waiting for that money so long. Now when it come, when they tell you sign, you're just asking them where to sign. And
Maxron,
yes.
Maxron,
So I'm saying that's an issue. You know, that's an issue that I really think needs to be addressed. And purchasers should know that too. Because, you know, at the end of the day, they might tell you, well, went by a lawyer and signed the mortgage already. Because they see you doing not that part, the bank lawyer doing that part, you doing another part. But in fairness to the purchaser who does not understand what is happening, it's two parties that signing that mortgage too. It's the purchaser who has a lawyer and the financial institution's lawyer. And yeah, so
Maxwell, I was going to ask, is that an experience in St. Vincent too, where sometimes borrowers just throw up their hands?
What I noticed in St. Vincent is where the and it's funny because I was having a conversation with a colleague of mine a few days ago on a similar topic, where he said to me that he was having a challenge with basically selling a particular person's property, and he said that the person said they didn't understand what they were signing when they signed the mortgage. Now, what I also find happening in St. Vincent and where this is concerned is that most persons, they don't usually seek legal advice when they are signing mortgage deeds. Because what happens is that the bank says to you, well, our lawyer is XYZ, that is where the mortgage is going to be. Sometimes you find that some persons will come and ask for legal advice concerning the mortgage and so on. But generally, you find persons, they're just concerned, oh, I'm getting this money and I'm going to build. And there's a thing that people say in St. Vincent that is as far as understanding how a mortgage works, where they say, well, the bank owns my house right now until I pay off the money. And then that has its own set of issues. Because what you find happening is that the absence of legal advice is that persons would then pay off the mortgage and they're happy and they're like, well, I don't pay off the mortgage. And guess what? They didn't get a reconveyance. And then they die, or they're to sell the property again, and you do a search and you find that it's subject to a mortgage, and they're like, what do you mean I have a mortgage? I don't pay that off. But they didn't get it reconveyed again because of the absence of legal advice. So it is something that we've been seeing, and it happens too much, especially when it comes to doing an estate. You do a search and you find, oh, it is still vested in the bank. And a challenge that has been for me recently is that some financial institutions no longer exist. So, for example, in St. Vincent, they had a bank called Agriculture Loan and Credit Bank. And that bank existed in the 60s. And in modern day, there is no such thing as the Agriculture Loan and Credit Bank. So that also presented its own set of challenges. And what was interesting about that, the bank that took over that financial institution, that bank went into receivership. And that presented again its own set of challenges.
I think Christiana Lashington is asking a question. I'm not clear what it is. Can one still save after by paying off the mortgage earlier and paying the penalty? I'm not clear what it is.
I think she was asking, because Casey mentioned persons sometimes try to pay off their mortgage early, and they do not know that there's a risk in doing so as well. So I think Christiana is asking this question with respect to this. Can one still save after by paying off the mortgage earlier and paying the penalty?
Well, it depends on your financial institution.
Yeah.
I know in St. Vincent they have some financial institutions that allow you, as long as you give notice, and the penalty is usually 3 months interest. So it really depends on the financial institution, and some financial institutions might say that you can't pay off the mortgage unless 5 years has passed, and so on. So it really depends on your banker.
And there is sometimes a term in a mortgage which says that essentially the bank, the lender, they tell you what is the interest rate, but there will be a term saying that it can be adjusted by the lender. Meaning it could be adjusted upwards, it could be adjusted downwards, of course. In your experience starting Maxron, have you ever come across a situation where the interest rate is increased?
I've not come across that, but what I've noticed is that sometimes, as you pay, some of them would reduce the interest rate when you get to a certain year. I have seen that, but I've not seen where the interest rate increases.
Yeah, we
Casey?
can go either. And again, those depend on market conditions. You know, the variables within the market, but there's a clause which you can use either to increase or decrease it. But again, with competition, one has to be guarded because interest in the first few years of a mortgage, you essentially paying interest. Um, the it's only after several years then you start to depend on a big mortgage on the principal, and that's something again people are not necessarily clear about, and why public education is important because they're paying, and when they're paying they're checking out the principal going down,
He will not
but the
talk,
principal is not being touched. You might say after a few years, why pay
just
all
scratching
this
it,
money and I still owing the same thing?
scratching
Something had to
it.
be wrong here.
Mm,
But it's just really about understanding, and again why knowledge is power in circumstances like those. So and that's why programs like these are so critically important.
Because
So people
a
can
mortgage
understand
is
the fundamentals.
so many people. It's almost part of the life cycle. At a certain time, you are very likely to enter into a mortgage loan. And then so many people get into that and they don't understand. So that's why I was asking you about the specific question because it happens in Grenada, as you heard Casey said, namely where people you just don't know what to do. Let the bank do what they want. And I think before we came on, you were mentioning something 5 years. And in those situations, people sit comfortably because they shut their eyes, they feel, well, maybe it may never happen. The bank may never come calling. And they're here 2 years, 3 years, me paying nothing. But then, the day will come. So it's really important to be on top of that. So before we end again, I just want to thank the sponsors of this program, Jail Professional Solutions. JBFM carried the program out of on FM radio in Canada and also Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Yes, I was saying to Maxron just before we started the program that in retrospect, it might have been very good to have a bank on the program also. But maybe in the future we'll look at it. So final comments, Maxron, we start with you.
Yeah, thank you. Thank you for having me. I think where this particular issue is concerned, we need to have more public awareness, especially when it comes to property and property transactions, because there are some things that I only found out about property transactions when I became a lawyer, and I was surprised. And I think that programs like this, we can bring awareness to persons, because when persons are aware, it avoids a lot of legal headache, as I like to call them, especially where investigating title is concerned and where having a reconveyance is concerned, and understanding how a mortgage works. And I wish for persons to also know the importance of legal advice. The bank's attorney is really the bank's attorney, and it's not your attorney. So when you're faced with these transactions and you're having a difficulty understanding what is going on, it is very important that you seek the advice of counsel in an effort to avoid some of the penalties that might arise if you default on your mortgage.
Yes, PC.
Yes, well, I always concur on the need for more and more programs, especially in these very technical areas of the law. And it's not really embarking on the study of law, but really understanding the fundamentals. Because I believe once you understand the fundamentals, many mistakes could be avoided. And understanding our land system in Grenada, because much of it goes to the land system. Sometimes transactions get held up for ages, especially now where you have people waiting on the issuing of letters of administration in the states, and these things have been taking some time. In fact, they have been of deep concern to lawyers. But I believe the situation is being addressed, because if these things are not addressed, it has wider impact on the economy and the efficiency of doing business. So it not only just affects the individual concern, but it impacts the wider economy. And again, in programs like these, you tend to remember that we need a new system. We need to move closer to the registered system of conveyancing to prevent all of these hassles associated with the unregistered system. There must be a reason why Grenada and St. Vincent are the only two countries remaining with the full unregistered system. Other people still use it. It's more like phasing out from the unregistered to the registered. But we don't have registered at all. All the other countries have an element. And sometimes I'm really surprised that the banks and financial institutions don't push more for it, especially with the state of our deeds and land registry, the state of the records. And when people say, well, the records getting worse, it was so bad years ago that I can't imagine it being worse. And because it affects the bottom line, which is your ability to verify vendor's title. Your ability to do so is seriously compromised. And that is the essence of what is involved in a land transaction. Verifying the title of the vendor because you're paying the vendor. But stripped of everything, what you pay the vendor for is the legal title to the land. The land and moving is a legal title that moves. So it is something that we have to continue to advocate for. And I trust that the Bar Association would keep this front and center, the need for that registered system. Because if serious advocacy is not done, everybody will acknowledge the need for it, but it just wouldn't happen. And it is so important that it really and truly must happen. At least we have the Possessory Titles Act now, that where people who have been in possession of land for ages have all structures on it but don't have legal title to it. There's an opportunity there to get some form of title based on your long possession. But even that has its challenges. There are a number of matters before the Court of Appeal over interpretation of certain sections of the Possessory Titles Act. But it's based on, it has been since 2017, now 8 years in 2025. And all of the little issues and challenges will do well to make the requisite amendments to the Act to cover those challenges. So we have some doing to do in the area of our land department, our land registry, our land system. And hopefully the programs like these will play a role in sensitizing the public and getting the public to join in making sure that those calls are answered. Yeah, it's an expensive system, but it is worth the while.
Thank you so
So
much.
again, thank you for the program. Thank you for having me on the program, and commendations as usual for a very important topic. Very topical, and very important for people to understand.
Thank you so much, Casey. I just wanted to read a comment from Bob before we go. Very excellent program, hosts and panelists. You gave very good information tonight, and my hope is that it reaches the intended people. Buenas noches. He also says, Casey, you can say it without fear or favor. The system needs to be digitalized. And with that, I just want to thank both Casey and Mr. Holder, Maxron Holder, for joining the show this evening. Surely the information you gave to the audience was enlightening. I saw persons were pretty engaged on the chat this evening. And we thank you both and do have a pleasant evening.
Okay.
Thank you.
Well,
Thank
night
you.
all.
Good night, listeners and viewers.
Good
Bye.
night. Good night.
Okay.
Okay, guys. Bye.